Really appreciate your time tonight. Thank you.
You bet. Rachel, did you compare me at the tease to the George Foreman grill? Because if you did, that may be the nicest thing anybody's ever said about me.
The fat rolls down. It's really different. Yes, in that construction, you would be the grill and not the chicken burger.
Okay.
But let's talk about the chicken burger. The president's son, you came out of this 8-hour-long stretch of testimony with the president's eldest son today, saying that he had claimed there was an attorney-client privilege between him and his dad, and that's why he wouldn't testify about their conversations. I'm quite sure I don't understand what he might have meant by that.
Well, that was the claim, that he wouldn't reveal the conversations he had with his father after the emails about the meeting at Trump Tower became public, because he and his attorney claimed they were protected by the attorney-client privilege. I think the claim was based on the fact that there were other attorneys present. But as I understand the privilege exists between the attorney and their client to protect communications where you seek from your attorney counsel about your particular legal situation. They can't be used to shield conversations between two people who don't enjoy the privilege between themselves. And I don't think this claim can be maintained. The only question is, will the House insist on getting the answer?
Mm-hmm. What was he being asked about when he gave that as his reason for not answering?
Well, specifically, he was asked, did you and your father discuss that June 9th meeting at any time, and tell us about those conversations? Now, a lot of this difference in perspective that you played earlier between Mr. Conaway and myself goes to a very fundamental question, which is, will Congress insist on getting the answers, or will we take, I'd rather not answer that question, along with a meritless claim of privilege as the last word? We had this issue come up, as you pointed out, last week with the Attorney General, who wouldn't answer a question about whether the President of the United States had ever instructed him to take action which he believed would hinder the Russia investigation. That is also not privileged. But Congress's ability to get the answers is only as good as our willingness to insist on it. Otherwise, we not only don't get the answers in our investigation, but we set a precedent for future investigations that you can stonewall Congress just by making an illusory claim of some sort of privilege.
One of the other ways that people get pressure to answer these questions when they initially refuse to is when people become publicly aware of the fact that they are refusing to answer these questions. And you've made some of that information public when you talked about Attorney General Jeff Sessions refusing to answer a question about the president, when you talked about what Donald Trump Jr. did today. The other ways we've had access to information about these sort of things, though, is when we've had transcripts. We got a transcript today of Eric Prince's testimony to your committee. We have seen a transcript of Carter Page's testimony. But we're told that there won't be a transcript of Donald Trump Jr.'s remarks today. We know that there wasn't a transcript for Attorney General Jeff Sessions last week. How do these things get decided in terms of whether we get a transcript or not?
Well, very arbitrarily by the majority. We had a practice where we weren't releasing transcripts, and without consulting with us, and for reasons that are not apparent to us, they decided to make exceptions when they choose. That's obviously not a good investigative practice. There are reasons to have these